Chapter 69. Counterfeiting and uttering counterfeit money. Section 818. Definition. Counterfeiting is making false money in the semblance of that which is genuine. Coining or uttering false money is a crime at common law, indictable on the same principles as cheating or forgery. In addition, federal statutes provide for the punishment of counterfeiting United States money. The principles applicable are very similar to those laid down in the chapter on forgery. Section 819. Distinction between federal and common law crimes. The Constitution gives to Congress power to punish the counterfeiting of the securities and coin of the United States. Under this provision statutes have been enacted, and the crime of counterfeiting, under the federal statutes, bears a somewhat different aspect from the common law crime. The federal courts have complete jurisdiction of the crime under the federal statutes, but the offense is indictable in the state courts as a common law crime, or under state statutes, as an offense in the nature of a fraud. Under the federal statutes, the crime is the making of something in the similitude of the coin or securities of the United States, and it is essential to the crime that the imitation exists, though it is sufficient if the imitation be calculated to deceive a person using ordinary care. Under some state statutes it is unnecessary to show similitude to genuine coin. Section 820. What acts have been held to be counterfeiting? There is much variation in the language of the different statutes against counterfeiting. Under a statute making it a crime to make an instrument in the similitude of a bill issued by a bank established by law, a note not like that of any known bank, but purely fictitious, is not included, but if the note purports to be issued by a bank having authority, it is not necessary that it imitate any bill which the bank has actually issued. Generally, it is held that a token which does not purport to imitate any known coin is not a counterfeit. It is usually held that the offense of making a counterfeit coin is not indictable if anything remains to be done to complete the coin. To file off the edges of a true coin, and fraudulently make a new milling, is counterfeiting. All persons taking part in the making are principals. Under statutes which forbid the making of counterfeit coin, intent is immaterial. Section 821. Uttering counterfeit coin. The uttering of counterfeit coin, that is, offering counterfeit coin with intent to defraud, is also a crime. Staking such coin in gambling is an attempt to utter or pass it, and losing it in gambling is held indictable. Also, it has been held an uttering to pay it to a woman for sexual intercourse, to take a true coin offered in payment for a sale, substitute a false one, and claim that the coin offered in payment was bad, this being known as ringing the changes, to give it to a confederate to pass, to offer it in payment though it be refused, or even to give it to charity, though it was formerly held that the latter was not uttering. Selling counterfeit coin is an offense distinct and different from uttering it. Under some statutes, it is an offense to have counterfeit coin in one's possession, with intent to pass it as true, or intent to put it in circulation, the two offenses being different, and the latter including the selling of it. Where the indictment is for selling counterfeit coin, it is immaterial that the purchaser believed he was buying counterfeit money. Where the coin is found in one's possession, guilty knowledge may be inferred from continued possession, and intent from circumstances. Section 822. Possession of counterfeiting tools. It is a misdemeanor at common law to have tools for counterfeiting with intent to use them. There are also statutes declaratory of the same crime. Under the common law, or the statutes, the following have been held to be tools for counterfeiting: a mold with the stamp of one side of a coin, though useless without the reverse; a press for coining, or an iron collar to mark the edges of the coins. But the having of an instrument which is not fit for use, as a mold with no opening for the metal to run, or an instrument which may also be used lawfully, as a crucible, is not a crime. It is essential that the tools should be had for the purpose of making counterfeit coin, and that there is an intent to use them, but such intent may be inferred from possession, and it is enough that another is to use them,